Hey.
Okay, we're up.
Not by anything we can actually access later, but yeah.
New York Racing Parimutuel Wagering and Breeding Law, Section 102, provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor, by and with the advice and consent of the Senate. 4 members confirmed by the New York State Senate are necessary to afford the commission an ability to establish quorum and undertake action. This present meeting of the commission is now called to order. This meeting is being conducted by video conferencing in 2 locations, New York and Schenectady. Both locations have been appropriately noticed and accommodate public attendance. Ms. Secretary, will you please call the roll?
John Crotty,
Here.
Peter Machete,
Here.
Brian O'Dwyer,
Here.
Marissa Shorenstein, here, Jerry Skurnick.
Here.
Ms. Secretary, please have the record reflect that a quorum of qualified members are present, thus enabling the transaction of business. Please note that Commissioner Machete is in Schenectady. Bilateral visual and oral communications between the 2 meeting locations has been established.
Minutes of the commission meeting conducted on March 27th, 2023 have been provided to the members in advance. At this time, I'd like to ask the members, are there any edits, corrections, or amendments? Hearing none, Ms. Secretary, please let the record reflect that the minutes were accepted. I now call on Mr. Williams for a report of the Executive Director.
Thank you. There have been a few developments within our industry that I would like to share. The state budget's been completed. The Horse Racing Integrity and Safety Authority Anti-Doping and Medication Program has stopped, and is starting again. Vernon Downs Casino Hotel has indicated they would be closing in the future. PointsBet has made an important announcement regarding their future, and I'd also like to provide some background information regarding the Pletcher meloxicam drug positive. And then I'll conclude with the status of the request for applications, questions, and answers in round 1. First, when we last gathered, I had outlined the gaming components.
Only if you're listening. Okay, go ahead. Sorry.
When we last gathered, I outlined gaming components of the New York State Senate and Assembly one-house resolutions regarding fiscal years 2023-2024. The state budget has since been finalized. Overall, there were 5 parts that were gaming related. In Chapter 56, there were parts J, J, and OO. From Chapter 58, there was Part R. From Chapter 59, there were parts X and BB. Part JJ of Chapter 56 amended the manner of composition of the Board of Directors of the Western Regional Off-Track Betting Corporation. Historically, the Western Board has been comprised of 17 members, 1 each from participating counties and 1 each from the cities of Buffalo and Rochester, with the appointments being made by the county governing body. The revised appointment law maintains the 17 members, but allocates their voting strength based upon a weighted percentage by population. Accordingly, Erie County will have 24 votes, Monroe 20, the city of Buffalo 10, the cities of Niagara and Rochester 8 each, Chautauqua County 5, Oswego 4, Cattaraugus, Cayuga, Steuben, and Wayne counties each have 3 votes, Livingston and Genesee counties each have 2 votes, and Wyoming, Orleans, Seneca, Schuyler counties all have a single vote. County executive and city mayors will take over the responsibility for making new appointments for the respective municipalities. For counties without an executive, the appointment is left to their boards of supervisors. Part OO of Chapter 56 allows Capital and Catskill Regional Off-Track Betting Corporations to access certain of their capital acquisition funds for the purposes of expenditures necessary to accept authorized wagers, pay past due statutory obligations to New York licensed or franchised racing corporations or associations, pay past due contractual obligations to other racing associations or organizations for the cost of acquiring a simulcast signal, pay past due statutory payment obligations to the New York State Thoroughbred Breeding and Development Fund Corporation and the Agricultural and New York State Horse Breeding Development Fund, and pay past due obligations to the state. Prior to a corporation being able to utilize the funds, they must attest that the surcharge monies are being held separate and apart from any other amounts retained, and they have been and will continue to pay the localities as prescribed by law. Once this condition is satisfied, the corporation must submit an expenditure plan to the Commission for review, which must include the corporation's outstanding liabilities, projected revenue for the upcoming year, a detailed explanation of how the funds will be used, and any other information deemed necessary to detail such plan as determined by the Commission. Upon review, the Commission will decide as to whether the requirements have been satisfied, and if so, authorized access and use. Part R of Chapter 58 dedicates $1.5 billion in licensing fees if the 3 downstate casino licenses are awarded, and a share of an estimated $231 to $413 million in incremental tax revenue from the casinos for MTA operations. Part X of Chapter 59 authorizes the New York Racing Association to enter into a repayment agreement with the state for the repayment of funds provided by the state for the renovation of Belmont Racetrack. The legislation allows $455 million loan to NYRA, secured by the revenues they presently receive from machine gaming activity at Aqueduct Racetrack. The loan will allow NYRA to replace the existing grandstand and clubhouse. The present structure, which was last renovated in 1968, will likely be replaced by a smaller facility with more modern amenities and hospitality offerings. Part BB of Chapter 59 is functionally an annual extension of sunsetting provisions regarding a multitude of provisions related to simulcasting of horses and certain tax structures. When we last gathered, I mentioned that the Horse Racing Integrity and Safety Anti-Doping and Medication Program implementation was scheduled to start that day on March 27th, 2023, as the Federal Trade Commission had approved the HISA rules. Recall the HISA program administration was to be effectuated by their selected vendor, the Horse Racing Integrity and Welfare Unit, which was established last year by Drug Free Sport International, a privately held corporation that offers drug testing and compliance services. Anyway, the Federal Administrative Procedures Act requires the tolling of 30 days between the final behavioral rule, when the final behavioral rule is issued and when it may take effect. Accordingly, when horsemen's organizations in Texas challenged the implementation on March 31st, the U.S. District Court for the Northern District of Texas enjoined HISA, finding a procedural administrative violation. HIWU immediately pulled all of their staff nationwide, and the Commission in New York filled the void by returning to take and test biologic samples. As we approached the 30-day expiration of the 30-day stand-down, the Federal Trade Commission announced that it would allow HISA rules to become effective on May 22nd, which is today. So HIWU is back in business, undertaking the responsibility for the biologic sampling of horses competing in thoroughbred racing in New York, as well as out-of-competition testing for horses eligible to compete. HIWU and HISA will also be undertaking the testing of the samples, evaluation of results, and the investigation and prosecution of transgressions. Commission barn staff who had transitioned from employment with the Commission and were engaged with HIWU as independent contractors performing similar duties, only to retransition back to the Commission, have now again been retransitioned to HIWU as independent contractors. Relative to Vernon Downs, on May 8th, 2023, Vernon Downs Casino hotel owner Jeffrey Garral circulated an internal memorandum to all Vernon employees stating his intention to file a State Worker Adjustment and Retraining Notification Act paperwork. He had indicated an intention to close the casino in August, the racetrack in September, and the hotel in December. 3 days later, he made good on the proffered intention, filing a WARN Act notice with the State Department of Labor. Mr. Garral has once again blamed the state by pointing to the legislature's refusal to eliminate the statutory employment requirement, which would allow him to receive an additional 7.5% of the state's administrative fee retention. In fact, this additional vendor fee is forfeited for any period that Vernon fails to maintain full-time employment equivalence to levels of at least 90% of its 2016 levels. The employment thresholds were also necessary for Vernon to be eligible to receive an additional vendor fee equal to 6.4% of its net machine income. There has been some public confusion that the Commission has discretion to waive the employment requirements. We do not. Both the initial implementing law and its practical extension allow for the additional compensation so long as the required employment levels are satisfied. As a reminder, in 2017, Mr. Garral issued WARN Act notices as part of what ended up to be a successful effort to obtain legislative relief. As you may have read, heard, or seen, thoroughbred trainer Todd Pletcher received a 10-day suspension and a $1,000 fine for violation of the Commission's rule regarding the presence of a prohibited substance in a racehorse. His horse, Forte, which won the Hopeful Stakes at Saratoga, was also disqualified. Specific to this incident, Forte's primary blood sample detected a presence of meloxicam, a regulated non-steroidal anti-inflammatory drug. The presence of such drug is not permitted at any level. Mr. Pletcher has administratively appealed the stewart's decision. Racing media in this matter has been substantial, as Forte was the 2022 Eclipse Award winner as a 2-year-old male and had been the Kentucky Derby favorite. The major focus of the attention has been the length of time between the incident and resolution. In large measure, the delay was due to split sample testing and efforts of Mr. Pletcher's attorney to delay the process. Recall it was in November of 2017 that a split sample program was initiated in New York at the specific request of the New York Thoroughbred Horsemen's Association. Under the program, in the event of a positive test, horsemen have the option of sending a split sample to an independent laboratory to verify test results. Before I venture further, while I'm discussing the practice and procedure in this case, please be aware that it is also applicable in harness racing. Additionally, as the Commission has jurisdiction over biologic samples collected through yesterday, as of today, HIWU and HISA will be taking over any drug positives from here out in the thoroughbred. The Commission retains responsibility for biologic sampling and testing for the events that occurred up till yesterday, and will retain that obligation in harness racing, as HISA has yet to address that industry. But by practice and procedure, when there's a possible rule infraction or violation, the stewards set a time to meet, providing an affected party an informal opportunity to address the matter. Following the meeting, the stewards collectively evaluate potential rule infractions, and if appropriate, the state steward will issue a ruling. In the present case, following being informed of the positive meloxicam finding, Mr. Pletcher retained counsel who sought to have the split sample tested. Unfortunately, Mr. Pletcher's attorney took nearly 2 months to select a qualified laboratory to conduct the testing. Then, following the return of the sample confirmation, the Commission steward offered 3 dates for the meeting, one of which was accepted. 3 days before the scheduled meeting, Mr. Pletcher's counsel requested a postponement. The steward then offered 5 additional dates with the proviso that if the meeting did not occur by the last date, the stewards would deem Mr. Pletcher had declined the opportunity to appear and would move forward with the meeting in absentia. 2 days before the last date, Mr. Pletcher's counsel again sought an adjournment, offering no substitute date. The state steward declined Mr. Pletcher's counsel's request, and the meeting proceeded. Changes to the split sample procedure have been instituted to reduce the ability of an affected party to game the system. Absent extraordinary circumstances, from now on, a trainer advised of a positive drug violation will be afforded no more than 2 weeks to identify and make arrangements for the split sample to be tested. Additionally, upon notification of a split sample result being returned, the steward's meeting must be conducted within 3 weeks. If a trainer cannot appear within 3 weeks' time, they will be deemed to have constructively waived their appearance before the stewards, and the matter will proceed. Returning to the meloxicam positive, according to the National Institutes of Health, the drug is approved for use in horses in multiple countries as an oral suspension or injectable. However, a direct equine formulation is not available in the United States. Anyway, under the classification structure of both the Association of Racing Commissioners International and the Horse Racing Integrity and Safety Authority, the drug is a Class B drug for purposes of penalty. The ARCI recommends a minimum suspension of 15 days absent mitigating circumstances, while HISA recommends a 15-day suspension while considering mitigation and aggravating circumstances. Both call for disqualification of the horse from the race. As I mentioned, the penalty that's been imposed upon Mr. Pletcher has been horse disqualification, plus a 10-day suspension and a $1,000 fine. The commission has not issued a penalty for meloxicam positive in thoroughbred horse racing since 2013, when Dennis Lellman was suspended for 15 days, which was reduced to 7 days after he waived his right to appeal. Lellman's horse was also disqualified. There was also one meloxicam positive in harness racing. This occurred also in 2013 at Yonkers Raceway. There, the judge imposed a suspension and a fine being 30 days and $500, both of which were halved when the trainer, John Grasso, declined to appeal, and the horse was placed last. Finally, you should be aware that the procedural processing of split samples has remained constant since its initiation. The Commission does not announce medication infractions until considered by stewards and judges. As of this Friday, there were 3 outstanding thoroughbred and 2 outstanding standardbred split samples at either qualified accredited independent laboratories or awaiting determination through a meeting of the stewards or the judges. Relative to PointsBet, recently PointsBet advised that Fanatics Betting and Gaming had agreed to acquire PointsBet's U.S. assets for $150 million. The deal is expected to allow Fanatics to gain access to at least 15 states, including New York. PointsBet will retain its Canadian and Australian business operations. Fanatics is a large sports apparel and collectibles company who were part of a non-winning bid for the commission-issued mobile sports wagering platform provider and operator licensees in 2021. Fanatics launched its first retail sportsbook in Maryland in January, and in March launched a beta version of a mobile sports betting platform in both Tennessee and Ohio. Staff have been working with Fanatics and their representatives to provide licensing documentation and pre-opening requirements prior to license consideration. There will be no transfer of license. Rather, Fanatics is seeking to become the new owner of the ongoing license holding entity, PointsBet New York LLC, DBA PointsBet. The transaction itself requires staff review, and Fanatics will begin the process of the backgrounding investigation of it, its related entities, and persons who are designated as qualifiers. Published reports indicate that they have a goal of the start of the upcoming NFL season for Fanatics to assume control of the PointsBet entity, with PointsBet anticipating a shareholder vote on the deal in late June. Given that Fanatics is new to New York and the gaming market, when the ownership transfer is complete, I would recommend consideration of the transaction at the commissioner level. Finally, with regards to the current requests for applications, questions, and answers, in late February, I indicated a response for the first round of the Q&As was expected to take about 3 weeks. I was incorrect. While the responses are taking longer than expected, it's important to remember that the Q&As are a critical step in the RFA process, allowing for the clarification of requirements and to make necessary amendments to the RFA. Taking the time to do this right is crucial. And to be clear, there is no statutory or RFA mandated deadline for the response to each round of questions. It was purposely left open-ended to allow the staff and the Gaming Facility Location Board members to properly evaluate each question and answer to ensure accuracy and consistency in response. That said, staff continues to diligently review, answer, and refine the more than 600 questions that were submitted as part of the first round and draft responses to each. Several of the submitted questions have multiple parts that need to be dissected. Many questions are similar in content, requiring a parsing of meaning and intent to ensure a consistent response. All of the answers to the questions, given the scope of the process and the weight of the answers carry, they all deserve a thorough and robust consideration. I appreciate the patience of the potential applicants and the potentially impacted local government entities who undoubtedly understand the necessity for us to get our responses correct, and they understand that there is no expectation for when the first round will be complete. Once the first round is completed, we will notify the public by publishing the responses on the Gaming Facility Location Board website at nycasinos.ny.gov. Mr. Chairman?
Thank you, Mr. Williams, and I particularly give you my thanks and the thanks of the commission members in setting the record straight in regard to the Fletcher matter. I think it's very important and was quite unfortunate. Some of the reporting that came out, the board and the commission and our staff needs to be commended for the way that they handled it. I understand there was a time difference, but they did everything they could to give Mr. Fletcher considerable due process, and I'm glad that you were able to correct the record in that regard.
Can I ask, Mr. Chairman, do we have any other horses now that have tested positive and are waiting for a split sample?
I think I mentioned there are three that are out there, and the thoroughbred and 2 from the standard bred.
Do you have a timeline on resolving them?
I don't know the specifics of any of those cases.
Okay.
I suspect, Mr. Crotty, given the situation, Commissioner, that we will be very, very diligent in terms of making sure that those things are adjudicated much more promptly.
Yep.
Thank you. Get now to rulemaking. New York State Racing, Parimutuel Wagering and Breeding Law 10419 authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibilities. To that regard, the Commission will from time to time promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. To date, we have one rule for adoption consideration and one for reproposal consideration. Mr. Williams.
For Commission consideration is the adoption of regulations to govern the content of casino license applications. The rulemaking process proposes amendments to reflect the statutory requirements of Title IIA of Article 13 of the Racing, Parimutuel Wagering, and Breeding Law concerning the application process for the additional casino licenses. The notice of proposed rulemaking was published in the State Register of February 23rd, 2023, meaning public comment period expired on April 24th. No comments were received. Staff recommends that the Commission adopt this proposed rulemaking.
Commissioners, any questions on the adoption of the amendments to rules governing the content of gaming facility license applications? Hearing none, may I have a motion to adopt the rule?
So moved.
Second?
Second.
Second. Commissioner Shorenstein, Commissioner Skirna. Discussion on the motion? All in favor?
Aye.
Opposed? The motion carries unanimously. Next item, please.
At the February 27, 2023 meeting, the Commission authorized proposal of rules to regulate advertising, marketing, and promotions concerning sports wagering. The proposal is undergoing customary review before publication in the State Register. Included in the proposal is a prohibition against compensating marketing and advertising third parties based on the volume of patrons, wagers placed, or outcome of wagers. Upon further consideration, staff believed that the proposed regulation would effectively prohibit affiliate marketing businesses from being compensated, which was unintended. New York Racing, Parimutuel Wagering, and Breeding Law Section 1341.1 generally prohibits agreements in which a payment of any direct or indirect interest, percentage or share of any money or property gambled at a gaming facility, any money or property derived from gaming activity, or any revenues, profits, or earnings of a gaming facility. However, fixed sum compensation is permitted. Accordingly, staff proposed to allow the compensation of affiliate marketers consistent with the New York law. Additionally, staff recommend an additional amendment requiring disclosure of business practices on the websites of such affiliate marketing sites. Staff recommends that the Commission authorize the proposal of this rulemaking as revised. If the Commission authorizes, staff will resubmit the revised language as superseding text in the regulatory review process.
Commissioners, any questions on the reproposal of the rules? I would like to make the following comment on that, which is that what we're doing today is allowing third-party marketing, and I understand that that is probably something that has been done in other jurisdictions. I personally will be looking very, very carefully at the marketing in the next 6 months to a year as to see whether that, in fact, is appropriate and that the advertising is done in such a way as to be efficacious, but at the same time that will be cognizant of the questions of problem gambling that we have been that have come to the forefront. If I find that within the next 6 months to a year that there has been significant problems with the type of advertising that's coming down, I will come back to the staff and to my fellow commissioners and ask that we revisit that rule and prohibit third-party advertising. I'm for it at this point in time, but I think it needs, as we all know that this is something new, we need to look at that, see how it goes, and then reevaluate it at the appropriate time. Does anyone else have any questions or comments? Hearing none, I'll take a motion.
So moved.
Second.
Any discussion? Hearing none, all in favor?
Congratulations to you, Mr. Chairman. I'm spearheading and putting this sort of initiative together. It wouldn't have happened without your sort of thoughts on it.
Thank you.
I think it moves us in a good direction.
Thank you, Commissioner. And I look forward to that, to our thing. I think all of us have been very, very worried about the whole question of college advertising. I think this was going to take care of it, luckily. Matter for adjudication. Mr. Williams.
On December 22nd, 2022, the Bureau of Licensing issued a notice of license suspension to Naji M. Mahmood, doing business as NA Market on Midland Avenue in the city of Syracuse. The notice informed Mr. Mahmood of a suspension for engaging in conduct that constitutes a fraud, deceit, misrepresentation, or conduct prejudicial to the public's confidence in the state lottery. Specifically, the notice cited Commission Rules 5001.19A4 and 5001.19A6, which authorize suspension or revocation of a lottery sales agent license for violation of the acts, rule, and regulation of the Commission or the licensing agreement with the sales agent, or if the Commission finds that the lottery sales agent's experience, character, and general fitness are such that the lottery sales agent's participation as an agent is inconsistent with the public interest or convenience. The notice stated that the action was taken because the licensee was found by the Department of Taxation and Finance to be in possession of unstamped or unlawfully stamped packages of cigarettes. Following notice and opportunity, Taxation and Finance revoked Mr. Mahmood's certificate of registration as a retail dealer of cigarettes and tobacco products for a period of 1 year beginning on December 1st, 2022. The Commission notice stated that the lottery sales agent license suspension would be for 1 year or until the end of the suspension of a license to sell cigarettes that may be ordered by Taxation and Finance. A hearing was conducted on March 2nd, 2023. The hearing officer submitted a report to the Commission Secretary dated May 9th, 2023, recommending that Mr. Mahmood's lottery license be suspended for a period of 1 year beginning December 1st, 2022. The Commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered this matter and determined upon a vote of 4-1, Commissioner Muschetti voting in the negative, to sustain the hearing officer's report and recommendations. Any new or old business to come before the commission? Hearing none, before we adjourn, I'd like to mark the departure of Commissioner Christopher Riano, who recently resigned for personal reasons. I'm certain I speak for my fellow commissioners and staff that we will miss him, the enthusiasm and the kind words and the analysis that he brought to the commission. He will be sorely missed. Also, I'd like to mark the impending retirement this week of Brian Barry from the Division of Racing and Parimutuel Wagering. Mr. Barry has been with the commissioner or its predecessors for over 4 decades, 43.7 years, and has in recent years been responsible for the recruitment, staffing, and scheduling of senior personnel at racetrack. His is a thankless position, but integral to the conduct of racing. I want to note that the Barry family has been involved with the public service in the racing arena for nearly 50 years, as Brian's father, Bill, who was a personal friend of mine and one of the giants of the Irish-American community, preceded Brian's tenure, having served for a few years as chairman of the Racing and Wagering Board during Governor Hugh Carey's administration. I'd also like to note for myself just a few more things. One of the things that I think the executive director did not mention, which I very close to my heart, is in giving the appropriation to NYRA, the $400+ million, specifically within the legislation, was an oversight of the workers' housing in both Saratoga and in Belmont, which means going forward, the franchise board and the state of New York will have specific oversight for the first time to make sure that workers' housing is clean, healthful, and appropriate. I think that's a major change and a major step for the commission and for the state. I'm most grateful to our governor and to the leaders of the legislature for putting that within the legislation. It will make a major difference in the lives of the backstretch workers going forward. Finally, I just want to discuss the question of where we are going to be looking at fanatics, just to make sure that they are appropriate. The commissioner, for the first time, that's being bumped up from staff to the commission. That procedure will also be used when we finally get to the question of the new casinos. As you may recall, while the site selection committee makes the final determination of the 3 licenses, once that's done, then this commission then must make a determination as to whether those 3 entities should be licensed to operate a casino in New York. I just want to put everybody on notice that is not going to be a rubber stamp by this commission. A lot of people who may have backgrounds that may need to be looked at will be looked at, and we will be very, very careful to make sure that, once again, that the casinos are operated with the greatest integrity. With that, that's all I have. Does any of the other commissioners have anything to say? None. I will take a motion for adjournment.
So moved.
We are adjourned. Thank you, gentlemen and ladies.